Hello, everybody. Good evening, dear friends and supporters of the Käte Hamburger Center for Advanced Study Law as Culture. We are very happy to receive a talk given by Christoph Schönberger about the constitution of things. Sounds very dramatic. Does it mean the structuration of things, or is it really the normativity of things? How things may have a normativity in themselves? A lot of questions, even behind the title. From the beginning, it has been a major aim of the Center's research to free the understanding of law from a pure textual understanding. Therefore, we try to work out a symbolic as well as a ritual dimension besides the organizational and, of course, the normative structure of the law, including its materiality. This perspective has been further explored in one of the recent publications of the Center. You might have seen that, Dynamics of Constitutional Cultures, edited together with Jan Suntrup. So I have to present you, of course, the speaker of the evening, who speaks not only, if I understand right, for himself, but also for Sophie Schönberger, who might correct him whenever she wants to do that, holding Anna on her arm. Professor Dr. Christoph Schönberger studied law and philosophy at the universities of Bonn and Paris, so he's a Bonn guy. Then he had been research assistant at the Humboldt University in Berlin, got his habilitation, of course, and subsequently even worked as a lawyer in a supra-local law firm in order to become, and finished with his habilitation, as I said, about citizenship in and of the European Union. This was followed by a professorship in Frankfurt am Main and then in Constance, where you taught from 2006 to 2020, then afterwards being a professor of public law at the University of Constance and afterwards at the University of Cologne. You held various visiting professorships at the Benjamin Cardozo Law School. So you can imagine that with Peter Goodrich, who is in the scientific board, and with a lot of others, we are in close connection with this wonderful institution. NYU, the University of Paris 1, Panthéon-Sorbonne, and Panthéon-Assas Paris 2, where I will give my seminars and lectures from next Monday on, by the way. You have been also a professor at Istanbul, at Koç University. So this gives you an impression of the wide range, not only of interests, but also of experiences, certainly also in constitutional matters. And I think if you follow up a comparative view, it is really necessary to have insights from the inner side of a certain scientific and a constitutional culture, as I would like to say. So since October 2021, you have been a fellow at the Käte Hamburger Center for Advanced Study in the Humanities, Law as Culture in Bonn. I will not try to go deeper into the abstract that you presented. You will do it yourself much better than I could ever do that. But it might be interesting for some of you that questions of the materiality of law, the space of the law, the specialization of law, even the buildings of the law, court buildings, court procedures, etc., had been studied at our center by Maria Bells, Patricia Bianco, Jose Maria González García, but this was always focused on the theater of justice, not so much on parliaments. And so this kind of field seems to be a new one and very interesting one, with also the question of similarities and parallels, etc. And you will talk about this today. I think it is always important for a presentation of a person what is something you really can't do in an adequate way. You know it, Christoph Schönberger, it is really impossible. One would need much more time for that. But for such an occasion, I think it's also important to know a little bit about the publications, in some major publications. One of the last you have realized with Matthias Jiestedt and Christoph Möllers and Oliver Lepsius has been the German Federal Constitutional Court, a court without limits. You might talk about this in our further discussion. It works about Reichsbürger, the vanishing of presence in democracy, the presence as an element in and this in times where we are looking for co-present situations and institutions. This must be very interesting to read it again. What you have read and written about the parliament as a European invention might also be related to what you might say later on about the material situation of parliaments. And I would like also to mention another publication that you have done im Archiv für öffentliches Recht, die Europäische Union als Bund. And this makes a link to our present main topic, law and Gemeinschaft. Bund is, of course, the third element between Gemeinschaft and Gesellschaft. Schmalenbach had invented this sociological category, though Bund, of course, has also an everyday life meaning. So with this short introduction, I would like to give the floor to Christoph Schönberger in order to listen to a fascinating topic, that is to constitute the things, the thing world. And it starts for me as a sociologist and a jurist with the question, what is a thing? For Emil Durkheim, it was the presupposition to do sociology. La première règle est d'observer les faits sociaux comme des choses. So this was sometimes criticized as a certain chosisme in Durkheim, but perhaps there is no constitutional chosism, but perhaps something that might be discovered by way of your reading the constitutional world.
Thank you very much, Mr. Gebhardt, for this nice introduction. I have prepared a little presentation. I'll talk to you about the constitution of things, and in thinking about this topic, everyone encounters a major difficulty, which is the difficulty of the current practice of constitutional scholarship, because the constitutional law scholarship tends to be text-centered. Text-centered, what do I mean by this? It means that it's centered on the written text of the Constitution. It's centered on court opinions about this written text, and maybe law professors' notes, legal academics' writings trying to explain the Constitution. This attitude in modern constitutionalism, and especially in modern continental constitutionalism, based on written constitutions, is naturally, or leads naturally to a phenomenon which I would call the lack of attention for rituals and materiality. So in centering on texts, in developing a scholarship constituted by texts, when the text is the main object of scholarship, then obviously rituals, practices, and the material dimension of constitutional practices drops out of the observation. Of course, there has always been accompanying scholarship which was not, which considered insufficient this textual approach and tried to broaden the view. But in general, in constitutional law scholarship, this text-centered view still prevails. And that's one of the main reasons why these material elements are rather understudied in constitutional law scholarship today. Now, that has not always been the case. If you look at older layers of constitutional law in the pre-modern period, there you encounter a huge and rich research on constitutional law precisely conceived as ritual, where ritual is conceived as the key for understanding those pre-modern constitutions. I just use the name of Barbara Stolder-Villinger and her important work on the Holy Roman Empire and its constitution, which was not a constitution, of course, in a modern way. It was not a written constitution. It was not a textual constitution, but it was a constitution basically constituting of practices, of rituals involving objects in many different ways. And you can, if you read her fascinating constitutional history of the Holy Roman Empire, you get a sense of this observation with an attention for dresses, for garments, for high and low places, for front and near and rear rows, for right or left, and for sophisticated rules of behavior showing the place of every person involved in those constitutional rituals. At the time, you might say, constitutions were rituals. The constitution could not be even conceived without looking at these practices. And these practices, of course, in stratified societies, in pre-modern societies, constituted orders of precedence. Everyone had one's place with respect to other people, having other places, higher places. And at the time, constitutional position more or less equaled the social rank and the social status of the person involved. Of course, this pre-modern world is no longer our world, because our world is, in the Western world, a world of democratic constitutionalism, where the idea of equality. And so the rejection of social stratification is built in from the very start. So I mentioned Barbara Stolberg-Villinger not to say that we should study our constitutions in the same way she did she does for pre-modern constitutions. But I think she can heighten the awareness for ritual and material elements even in constitutional practice today. It would be wrong to think that the fact that we have passed to another situation of constitutional law based on written texts had completely left out this question of ritual practices and materials. And so we can use this rich reflection on pre-modern constitutions to better understand our modern constitution. I will mention the second example, which is not an example from the past, but from the present, which is very much shaped by past experiences, which is, of course, the example of the British Constitution. The British Constitution to this day is a constitution that does not fit the description as a written constitution. It's not a constitution centered on text. It's a constitution which is based on rituals, on practices, on rules, often unwritten rules. And of course, as you can see here in one of the pictures, this is the picture of the state opening of Parliament, of course, which takes place every year in Great Britain, shows very much that this is a constitution that must be seen to be working, that must be in place and must be used or must be shown to the public in a strong ritual. This, of course, is again not to say that we should use the British Constitution as key to understanding all written constitutions, even in continental Europe. But again, Great Britain shows to this very day that a constitution can very much be an order of ritual practices involving objects, and that must be taken into account into our reflection. That would be my proposition. Here in this kind of constitutional, you even have sometimes performative elements linked to things, linked to objects. I give you an example, which is one of the interesting and intriguing example of British constitutional law, which is the role of the mace in the House of Commons. What is the mace? The mace is, as you see here on the left, it's an ornamental staff. It's an ornamental staff which is there on the so-called table of the House. And the rule till this day is that a regular session of the House of Commons is only possible if the mace is there. If the mace is not on the table of the House, then no session can take place, no laws can be passed. The mace is, of course, an ancient weapon. It's a royal weapon, and it's a sign of royal authority in the House of Commons. So paradoxically, the House of Commons can only work if there is a royal symbol present on the table of the House. Here we have, of course, a thing, an object, which is enclosed in a ritual practice. At the morning of each day of the session, there is a procession with the speaker carrying the mace to the House of Commons and putting the mace in place. And recently there had been one accident in the House of Commons when a member of Parliament who was not very happy with the session as it went, took the mace and went away. And so the session could not continue. They had to recover the mace, put it into place, and then the session could continue. Of course, such elements may seem quaint to modern continental lawyers. They may be considered a British eccentricity, which is not determining in understanding the British Constitution. But I think such elements show an older layer of constitutional law where performative and ritual elements linked to objects were still important. And even if we look closer to us, if we look at German public law, there are remnants of this performative materiality even today in German public law, because still in the law of German civil servants, the legal rule is you can only be appointed a civil servant if the instrument of appointment, certificate of appointment, is handed over physically to you. So there is no exception to this rule, and it's, of course, it may seem quaint and even archaic, but it's still a valid practice in the law of German civil servants. And everyone who appoints people is aware of that rule, even if people don't know anything about the law. But it's kind of a tangible rule that can be easily understood and links us to this older pre-modern law world where rituals and objects were closely intertwined. Now, of course, you may say, or you may object to me, that may be true, but those are only remnants of the past. Those are only traces of older layers of constitutional law, which are no longer determinative for our understanding of constitutional law. And I would agree with you. But I would claim that what we have encountered now, what we still encounter, is the process whereby objects and rituals go from validity to legitimacy. They are no longer usually, they no longer have a performative dimension in the sense of legal validity. That's an exception, like the mace in the House of Commons or the instrument of appointment of German civil servants.
Excuse me, may I ask you to speak more directly into the micro? I have difficulties sometimes to follow. Perhaps it's not only my brain, but it may be just the acoustic sound.
Okay, I tried.
Can you try that? Excuse me for interrupting.
Tell me again if you perceive the problem still. So what I was just trying to explain is that we have witnessed a process by which constitutional law has gone from validity to legitimacy in terms of ritual and the performative dimension of materiality. Those elements, if they are still with us, are only remnants of the past. But at the same time, objects and rituals surrounding objects are still very much with us, but they are no longer there to assure legal validity for constitutional norms, but rather constitutional legitimacy. And in this dimension of constitutional legitimacy, they remain very important. That would be my claim. We have, of course, many examples of constitutional rituals involving objects. I give you some, but it's just to show that we have different practices where objects and constitutional proceedings are intertwined. One example is, for example, the election of the federal chancellor in the Bundestag. There, you may remember, because we just had one election in December, that there is a practice of the Bundestag that the bench of the cabinet, I will return to this problem later on, remains void in this session. So the Bundestag comes together, but there is no government official on the cabinet bench, showing that the Federal Republic has no constitutionally constituted government. It only has one once the chancellor is elected by the Bundestag and can legitimately take his seat on the cabinet bench. So here you have a ritual strongly involving an object, which is the cabinet bench, and even the void of the cabinet bench is used to show something important, which is that in this election of the chancellor, the fact that the chancellor needs the election of the Bundestag. There is no chancellor without an election by the Bundestag, and before even the official, still acting chancellor, constitutionally there is still an acting chancellor, usually the person holding the office before, is no longer sitting at this place, even although this person is still chancellor in technical terms. So here, one of the ritual elements. Other interesting ritual element is, for example, the swearing in of cabinet members by the president of the Bundestag, taking shape in the parliamentary chamber. And usually, the president of the Bundestag will use the original of the basic law. So the original instrument of the basic law, as it was drafted in 1949, will take it from the archive, go to the session of the Bundestag and use it for the cabinet members to read their oath of office. Of course, this is no longer legally binding. This is no longer performative in the sense it might have had in older constitutional times. But it still uses an object and an element as part of a ritual claiming legitimacy for the nomination of the chancellor and the members of his cabinet in the surroundings of parliament. And of course, you could go on, you could use the example of voting booths in elections, constituting a strong ritualistic element in elections. So there are different elements we can look at in this perspective. Of course, if we try to make sense of this, we encounter theoretical problems. Maybe not only the problems Durkheim talked about and Professor Gebhardt mentioned earlier on, the issues, but we have in the social sciences some theoretical offers and proposals we might use in one way or another when we try to make sense of objects in constitutional law. One of the most discussed offer is the so-called ANT, This is the so-called actor network theory, developed, for example, by Bruno Latour, which tries to explain that objects have a quality of agency of their own. It's a very strong theory trying to claim that objects have really agency, that they are actors as we are human actors. You might use the classical German St. Martin song, Ich gehe mit meiner Laterne und meine Laterne mit mir, to explain this situation. So the object gains an agency of its own in this theory. I'm not completely convinced by this theory because it tends to ascribe too much agency, in my perspective, to the object. And Latour is basically concerned with explaining scientific laboratories and scientific arrangements. So he's trying to show how modern research is shaped by the instruments of this research. Here, I'm rather concerned with social rituals and the importance of objects inside these social rituals. But nevertheless, Latour's offer is interesting because he shows that objects have a certain kind of agency of their own, and we can only account for the social practice involving objects if we look at the objects and their role inside the social practice. So that's one of the theoretical. Another theoretical offer we have is in political philosophy. Political philosophy has been for some time obsessed, or at least concerned, with the body politic and with the importance of the body in political language. You could call it maybe a political corporeality. We have different offers here. The problem with this kind of research is, in terms of material, or the material dimension of constitutional law, is that usually the only material dimension is really the human body. So it's really concerned with the human body, and it's closely linked to this difficult and venerable tradition of the body politic and of the idea that we have to conceive the political unity as a body with a metaphor of the human body as showing what political unity might mean. I'm therefore not so sure that we really can profit very much from this research for the material dimension of constitutional law, because precisely it's not very much interested in objects as a dimension of constitutional law, and it's often entrapped, in my perspective, in this very ancient tradition of the body politic, but in the metaphors, in political metaphors we used for a long time, especially in ancient Europe, for the political process, and it's not quite clear that we can still use this metaphor usefully. And the third possibility is, of course, ritual theory as we know it from anthropology or the sociology, especially the sociology of religion. Here we have a rich theoretical offer. What is lacking to this day is really a transposal of this ritual theory to the political field, to the constitutional field. So we have a rich theoretical offer, but it has not been completely thought through for the problems of constitutional arrangements and for the problem of political action, at least as far as I can perceive or I have read the literature. Now let me turn to one of the objects I study and try to study in terms of a constitution of things, which are the plenary chambers of parliaments. Of course, parliaments need a space to meet, and this space has to be arranged. So this is one of the main arrangements the constitution and modern politics has to make. And here we have to reflect on what plenary chambers are really about. If we start, of course, there is an obvious practical function because it's a meeting room. meeting room, usually for several hundred people. So there are obvious practical problems, and therefore often architects write about plenary chambers because they have huge problems in terms of heating, air conditioning, and so on. That's of course an important practical dimension, but it's not a practical dimension I'm interested in. I'm interested in understanding these plenary chambers in two ways. On the one hand, I'm interested in understanding them as an arrangement to shape the interaction of the people present in plenary chambers. So the spatial arrangement shapes the interaction. And on the other hand, and it's even more difficult to conceive theoretically, is that they usually constitute a non-verbal interpretation of constitutional arrangements. So I think the seating arrangements in parliamentary chambers are a powerful interpretation of constitutional arrangement, but an interpretation without words that speaks silently, but often not less efficiently for not being explained textually. And if we look at plenary chambers, we have these two dimensions. We have the interaction being shaped concretely by the physical arrangement, and at the same time, we have this non-verbal interpretation of the constitutional arrangement. So I conceive the parliamentary chamber as a privileged space for constitutional and political rituals as standardized and repetitive social interactions imbued with symbolic meaning. And that's what I would consider a parliamentary chamber to be. And therefore, looking at parliamentary chamber more closely, and especially at seating arrangements more closely, has this can teach us many lessons about the constitutional system in question. Winston Churchill had it right already in 1943 when he said in a speech in the House of Lords, "We shape our buildings, thereafter they shape us." So we have a certain agency in conceiving these plenary arrangements. Once they are there, they get an agency of their own. An agency maybe not as strong as Bruno Latour would have it, but at least an agency shaping what happens concretely in these interactions. Let me use the example to explain my point, a concrete example, which is the place of cabinets in parliamentary chambers. Usually, or often, parliamentary chambers are interpreted only in terms of the places of the members of parliament. So then people will look at the differences between the hemicycle on the French model or the opposing benches on the British model. That is not my main area of interest here. I use maybe a little bit an unusual perspective by asking the question, where do you put the cabinet? The cabinet, of course, as head of the executive, is usually, in modern constitutional democracy, the most powerful institution you have. So where you put this powerful institution inside parliament tells you a lot about the constitutional design, about the understanding of the constitution, or at least gives you some guidance as to where how this constitutional system could be understood. There is, of course, a certain tendency in modern political philosophy to be enthralled by Claude Lefort's classical metaphor that in democracies you don't have a place of power anymore, the place of power is empty. I would say at least this is not true for parliamentary chambers, because in parliamentary chambers you cannot avoid to place the powerful institutions. You have to give them a seat and a place, and therefore you, in one way or the other, have to interpret the arrangement. So it cannot remain empty. And therefore, parliamentary chambers are so powerful in explaining the constitutional structure to us. I'm very much aware that Claude Lefort is arguing at another level of argument. He is arguing in principle on the idea of, on his idea of democracy. I wouldn't argue with that, but I would claim that at least as far as parliamentary chambers are concerned, you cannot avoid to give a place to the physically present institutions or individuals, and thereby you have to interpret the constitutional system in one way or the other. Now let's have a look at the plenary chamber of the Bundestag and try to make sense of the places of the cabinet as we encounter them in the Bundestag. You are certainly, most of you will be familiar with this plenary chamber. We all see pictures of this chamber all the time, but usually we do not really reflect on this chamber. We take it as a given. We have a kind of a natural impression that this is the way things are. And I would invite you to discover with me a little bit that nothing is natural in this kind of arrangement. All is a certain way of shaping human interaction, and the question is, why do we shape it in this way, and how does this affect the interaction taking place in this plenary chamber? Now, you know that in my picture, the cabinet bench is on the right of the president, opposing the hemicycle of the parliamentarians. On the left side, for those who are not completely familiar with the German system, on the left side of my picture are the places for the so-called Federal Council. I leave them aside for my argument here. But my first remark would be we have to unnaturalize our observation of this. And how can we do this? Well, we can do this in the first place by looking comparatively at plenary chambers and looking at the question whether other systems use a similar arrangement, whether the system is rather unique, and that's one of the ways of liberating ourselves from the kind of self-evidence these chambers may have for the usual observer. And here, my first remark would be: if you look around at the around 200 plenary chambers of national states around the world, very few use this arrangement of cabinet places. The most important example in another country is Japan, but in Japan, it's the historical explanation is the close relationship between Germany and Prussia and Japan around 1900, when these parliamentary chambers were designed. But apart from Japan, you don't really encounter this system where the cabinet sits on the right of the presiding officer with this particular relationship to the parliamentarians. And I will show this to you by making a brief comparative brief comparisons with some other systems to show you how different these arrangements can be. If we look at the question of cabinet places in parliamentary chambers, you could say there are only three main possibilities to deal with the problem. The first possibility is to keep the cabinet out of the parliamentary chamber. So the president and the ministers will not be allowed to be in the chamber, to have seats in the chamber, to speak in the chamber. This solution is rather rare. It's a solution of a radical presidential system, but we have one important example, of course, that's the United States. The United States doesn't have seats for the president or for the members of his cabinet in the parliamentary chambers on Capitol Hill. And there is only one exception when the president is physically present. That's the famous State of the Union address once in a year when the president addresses both chambers in the House of Representatives here from the rostrum, from the Speaker's place in Parliament. Apart from this, there is no everyday relationship of physical presence between the American cabinet and the president and the American Parliament. So that's one of the solutions, but this solution is only imaginable if you have a radical presidential system where the executive is not responsible with respect to parliament. So that's one solution. If you have a constitutional system where there is some degree of responsibility of the cabinet towards parliament, as is of course the case in most parliamentary systems, then it's unavoidable to have seats of the cabinet in the parliamentary chamber. The question is, where do you put them? And then there are two other possibilities to do it. You can either place the cabinet with the members of parliament. So if there is a hemicycle, then you put them in the hemicycle, maybe in the first row or so. So the members of cabinet are integrated into the arrangement made for members of parliament. And the second possibility is, of course, you put them outside of the hemicycle, and then it's one way or the other close to the presiding officers. You have to put the cabinet because there are no other places around. You have the hemicycle. If you don't put them into the hemicycle, then you have to put them outside the hemicycle. So you're close one way or the other to the presiding officer. Let me show this give you some examples to show these models. On the one hand, I said you can integrate the cabinet in the seats for the parliamentarians. And the most important and classic example is, of course, Great Britain. Here you see the famous arrangement in the House of Commons. You have on the right of the speakers the row of the parliamentary majority, and in the first row you have the cabinet members. The cabinet members are in Great Britain parliamentarians. They must be members of parliament. If someone is not a member of parliament, he cannot speak in the chamber. So it's clear we only deal with members of parliament, and one group of members of parliament are forming the cabinet. They are in the first row on the right of the speaker. And on the other side of this mighty table of the House, there is the opposition, and the first row of the opposition, the shadow cabinet, eye to eye with the cabinet. That's the British arrangement. But what is important for me, for my main point here, is really this is not a separate cabinet bench, but it's a kind of differentiation inside Parliament. The cabinet is a certain kind of members of Parliament, and they are the leading group of the majority of Parliament. That's the British solution. Similar but different is the French solution. The French solution, of course, France has influenced the parliamentary seating arrangements across Europe and the world tremendously. And it has not only exported the hemicycle, which we have inherited from France too, but it has found an original solution to the problem where to put the cabinet, because they put the cabinet in the first two rows in the middle of the hemicycle. So the cabinet members sit in front of the orator and in front of the president of the assembly. So there is, if the orator speaks, he speaks immediately to the ministers in the first or second row in the middle of Parliament. Here again, that's not the British design, of course, but the similarity with the British design is you put the cabinet in the surroundings of the members of Parliament. You don't give them a completely special place, no separate place, but you treat them as part of this spatial arrangement dominated by parliamentarians. Of course, if you look exactly at the picture, you will see that at least these places have a golden inscription, Bon des Ministres. So there is a certain separation. They can only ministers and members of the cabinet can sit there. But the whole arrangement with these red seats is completely similar. And if you look at it from the gallery in the French Parliament, you even don't notice the places of government because of the cabinet, because they are so similar to the places of the parliamentarians. And I just note for the anecdote that the French have kept the system, although today the members of the French cabinet are no longer allowed to be members of parliament. under de Gaulle's constitution, there is a strict separation. So these people are not members of parliament, but they sit there as if they were members of parliament because the French tradition is so mighty and keeps them inside this hemicycle. If you look at both arrangements, the British and the French arrangement, I think one of the most important similarities is, of course, the direct interaction between parliamentarians and the cabinet. In Britain, that's obvious because they are across the table of the House. In France, it's obvious because the orator speaks from a place below the president, and he has the cabinet in face of him. So the orator can immediately challenge the cabinet sitting eye to eye with him. So this is interesting because we see that in different arrangements, certain ways of interaction can be similar without these spatial surroundings being completely similar. And here, a third example. This is an example of a plenary hall where the cabinet is not integrated into the hemicycle. This is the example of Italy. The Italian plenary chambers in Rome have an arrangement where there is a hemicycle, ascending rows. It's a little bit like an arena if you come into the chamber, and the government or the cabinet is in front of the hemicycle, but below the presiding officer. And there you see the prime minister is in the middle. Answers questions. So in Italy, you have immediate interaction between the parliamentarians and the cabinet. And I should add that there is no rostrum, so no Rednertribüne, no tribune in the Italian parliament. People speak from their seats, from their places, and so they have government immediately there, the cabinet, to interact with it in a meaningful way. Here also, it's an interactive arrangement, but completely different from the two arrangements I have with before. So it's, in my perspective, if you look at the parliamentary interaction, it may be not only determinative how the concrete arrangement is, but whether it allows meaningful interaction between parliamentarians and the cabinet. And all examples I showed you are examples where in one way or the other this meaningful interaction is possible. Now let's turn to the German case. Here I have to tell you a little bit about history. Why do I have to do this? I have to do this because parliamentary chambers across Europe have been invented in the 19th century. The seating arrangements we have all over the place are usually seating arrangements invented in the 19th century, and usually often kept in the way they were in the 19th century. So it's clear that if you want to understand the arrangement, you have on the one hand this comparative perspective, and on the other hand you need some historical perspective. Now the inventor of all this is Otto von Bismarck's German Empire. The Reichstag in Berlin in 1871 had its first own parliamentary chamber, and this parliamentary chamber was designed in this way. Here you see a picture with Bismarck at the place of the Chancellor. He's there on the left in uniform at the place where the Chancellor usually even still sits in today's Germany. It was a more lively parliament, as you can see, because people were standing around, and so pictures do not completely give the spatial arrangement. The arrangement was that there was a hemicycle, and you see here in the foreground of the picture, you see the members of parliament in the hemicycle, and then there was this huge cabinet bench integrated with the presiding officer. And it was elevated, it was higher, so Bismarck sits evidently higher than the parliamentarians below him. This was the beginning of the German cabinet bench as we know it today. It was invented for the Reichstag in 1871. It was invented, of course, in a constitutional system where there was no system of parliamentary government. It was invented where on this cabinet bench there were only high civil servants appointed by the emperor. they were there in this capacity as civil servants of the emperor, and they were not, of course, members of parliament. They were not allowed to be members of parliament. So there was a strict separation in the constitutional system, and this strict separation was, in a certain sense, embodied in the spatial structure of the Reichstag with this high elevated cabinet bench in 1871. Now, the interesting or intriguing phenomenon about the German development is that the early Bundestag of the Federal Republic kept this arrangement in place. So when the Federal Republic was founded, in a certain sense, it repeated the Reichstag arrangement of 1871. And you see here on the left, you see in the picture of the first 20 years of the Bundestag, you see a very high elevated cabinet bench with many, many seats. Of course, the members of parliament were in the hemicycle on the other side, and they were lower. So there was a huge distinction between high and low between the cabinet and parliament in the first 2 decades of federal Germany. There were many discussions I cannot repeat here, but in the end, in 1969, and that's the picture on the right, in 1969, the cabinet bench was lowered. So you see, it has not disappeared, but it's lower, and there are not as many seats as there were before, due to a long discussion in the early Federal Republic where above all, the Social Democrats, eternal opposition of the early Federal Republic, claimed that this was unacceptable in democracy. The cabinet had to get lower, and there shouldn't be as many places for civil servants and so on this cabinet bench. And that's where Germany arrived at the reunification. There was some efforts in between to come to a circle as a plenary chamber, but in the end we arrived at this arrangement. And this arrangement finally is still rather close to the Reichstag's arrangement of 1871. It's of course no longer elevated, so the cabinet bench is no longer higher than the parliamentarians, but the spatial arrangement fundamentally has not very much changed. You still have on the right of the president of the Bundestag these many places, many seats for cabinet members, and it's still in no obvious relationship to the hemicycle on the other side, because. And here we can now again talk about interaction. Now look at this arrangement and interaction between parliamentarians and the cabinet bench. How do you do this? If you are the orator speaking from the rostrum, as is the usual case in the Bundestag, you don't look at the cabinet at all. Yeah, the natural way of looking is towards your colleagues, members of parliament, as in the French Assembly. But if you want to address the cabinet, if you want to criticize the chancellor or a minister, you have to turn around. So you are in a difficult physical position. You have to turn around. You have to look at the bench. You lose the eye contact with your parliamentary colleagues. So this is obviously not an arrangement made for direct eye-to-eye contact between parliamentarians and cabinet members. And if you compare it to the other arrangements I showed you, whether in Italy, in Great Britain, or in France, every one of these arrangements has this interactive element. So this is an arrangement that, in a certain sense, precludes or makes interaction particularly difficult. And so that's I think an interesting observation. The same is true if people speak from their seats, because if you look at the arrangements of the hemicycle, and there is no evident spatial relationship to the cabinet places. So if you speak from your seat, you also don't have this immediate contact with the cabinet members, and you can see this very good if you look if you visit the Bundestag for a question period. You see that people, members of parliament, put questions from their seats, and they are far away from any cabinet member that might answer the question. So there is no direct eye-to-eye contact in the Bundestag on these matters. If we try to make sense of this, then of course we may say, well, this is just an inheritance from the German Empire when there was no parliamentary government, and they have kept it. But then the question is, why did they keep it? And they kept it many times. We changed parliamentary chambers many times, and we kept it. I would suggest three elements of explanation. The first is we have an arrangement that goes counter to the parliamentary government we have. We have a parliamentary government, so sitting on the cabinet benches are usually parliamentarians. All members of the cabinet, or almost all members of the cabinet, are also members of parliament. But they sit on the cabinet bench as if there was no relationship between the chamber and the cabinet. So in a certain sense, we have an arrangement that does no longer reflect the constitutional structure of parliamentary government. On the other hand, if you look at the general public, people usually like the idea of a strict separation of powers. If you look at opinion polls, people usually say, well, there should be a strict separation between parliament and the cabinet. Members of parliament should not be in the cabinet. Those are propositions many people like, and those popular misunderstanding of separation of powers can easily identify with this spatial arrangement. Second element is a certain aloofness of these places. These places are aside, they are apart, they are aloof of the spatial arrangement. And so this spatial arrangement seems to suggest that these people are not responsible to parliament. They are visitors in parliament. They just show up, but they are not really there to be asked, to be held responsible, to be controlled. And so the whole spatial arrangement gives a picture of a cabinet that is not really part of this interaction, but just a silent observer of an interaction that is not really as important for the institution. And the third element, and that's another, I think, difficult element of the arrangement, is this placement of the cabinet alongside the president of the Bundestag. Because here you have a spatial arrangement where the cabinet is close to what you call in parliament the bureau, the presiding officer, the president of parliament is sitting there, and close to him there is the cabinet. On the other hand, on the left side in my picture, there are still representatives of the executives from the German Länder. So the impression given by this arrangement is that the whole side around the president of the Bundestag is a kind of neutral, impartial, non-partisan space inside parliament. You have the seats of the parliamentarians, you have the rostrum, there's the place for debate, there's the place for conflict. And here are people who are sitting in a neutral, impartial, non-partisan. And so the spatial arrangements give the picture of a cabinet that is not really a political actor, but a neutral actor outside of this of these political quarrels. So in a sense, this plenary chamber is a powerful counterfactual narrative on the German constitutional system. The cabinet sits in the Bundestag as if it were not responsible to the Bundestag, as if it was separate from the members of parliament, and as if it was aloof and neutral from these political quarrels. Of course, that's not the case. But by giving this powerful image, it reinforces a certain way of looking at the constitutional system, which is very much in tension with the parliamentary government that is actually practiced in the Federal Republic of Germany. So in this sense, we have a constitution of things which is difficult to reconcile with the written constitution and the commentary on the constitution with the constitution as text. And I will leave it there, and thank you very much for your attention.
Thank you very much for this wonderful talk, full of irony and a really funny talk when we see how much there is a discrepancy between the constitution of things in the sense of parliamentary arrangements and settings with the spirit of the parliament. But in the end, one could ask, do the setting orders not qualify a certain kind of interpretation of the constitution? Could it not be understood as if the constitution of things would be part of a constitution that is not only constituted by words, but also by spatial arrangements? So where do you take your judgments from and the power to say there is this kind of discrepancy? And in the end, I would say you give more importance to the text than to the interpretation by things. Is it right or a wrong perception?
Well, let me put it this way. It's not only the text. Parliamentary government is very much a political practice. So that the cabinet is, of course, constituting the main politicians coming from the parliamentary majority is obvious. So in a sense, the seating arrangement that shows them as if they were aloof from the parliamentary majority, as if they were completely separate from them, does not do justice to this phenomenon. But I would agree with you that I think the spatial arrangement, the fact that it was kept, and it's different in Germany, let's say, from the case in France, where they are in the Palais Bourbon since 1798, and they use this plenary chamber since 1832, and it has never been changed. In Germany, we had several changes. We had the Bonn plenary chamber. We had even a reconstructed plenary chamber in Bonn in the 1980s, where they tried the circle. And then we had the change to Berlin and the arrival at the current arrangement since 1999. So at several junctures, finally, the old decisions made in 1871 have been reconfirmed. And so I would certainly agree with you that we must be intrigued by that, and we must ask ourselves, aren't there certain elements in the constitutional system, even today, that could be used in favor of this arrangement? And I'm sure I wanted not to be too long, but I could give you two elements where we could use it. On the one hand, the basic law still knows a clear distinction between Bundesregierung and Bundestag, between the cabinet and the parliament. They are considered separate constitutional organs by the constitution. So in a certain sense, there is a separation there. And if you insist on this separation as the main separation, then the arrangement is perfectly defensible. On the other hand, those institutions are closely intertwined in constitutional terms. The chancellor is elected by the majority of the Bundestag. And in our practice, political practice, it's even more obvious because we have closely knit parliamentary majorities supporting the chancellor, and so we have a parliamentary government in many respects even close to the British case, and we have this spatial arrangement that doesn't really try to give a sense of this. So I would rather argue that we have a tension inside the constitutional system, and certain elements in the constitutional system inherited from constitutional monarchy, by the way, they are reinforced by the spatial arrangements.
Thank you very much. May I ask a further question, and then I quit my position here. And I have a question to Gian Maria Ayani. The spatial arrangement may it be a reason for the rapid change of governments in Italy. Because the government is in front, they have to interact. Perhaps sometimes, we say always interaction is communicative, but sometimes it is important not to interact, to have no communication. So it's a speculation. But I would like to have your opinion on that.
Yeah, that's it's an interesting question in the sense that I think it's a hen and egg problem we cannot resolve. Because it's difficult to claim that, let's say, the rather cumbersome interaction between parliamentarians and the cabinet in the Bundestag, everyone agrees on that, yes, is a result of these spatial arrangements. I wouldn't claim that, but I would claim it's an interesting parallel. We have this spatial arrangement, and we have a system that has a lot of difficulties to establish mechanisms of oral control, question periods where the chancellor and the cabinet appear often in parliament to defend their positions. In the Bundestag, we have a lot of difficulties establishing that. I just might remind you that the first chancellor to really take questions in the Bundestag personally was Angela Merkel in 2018. So it's really a system where the direct challenge to the cabinet in person and in direct communication, as we have it in many parliaments, is really not very much used. And the spatial arrangement is an interesting parallel to this situation. And then I wouldn't say, I think we cannot really, we don't have a method to ascertain whether another spatial arrangement would yield better effects. I'm skeptical about such arguments. I'm not advocating for a change. I'm advocating for comprehension and for better understanding of the system by using these special arrangements. And therefore, for the Italian case, my answer would be similar. It's an interesting parallel. It's an intriguing parallel. And if you have been there personally in the chamber at Montitorio, and you get the impression of an arena. It's really an arena because the rows are ascending very much, so it's a kind of a Greek theater atmosphere. And there, low on the bench, are the cabinet members, and critique may come down on them from the parliamentary members.
I would like to listen also to an Italian voice regarding this question.
Yeah.
Gian Maria, it would be nice to have your opinion on that.
Yeah. Yes, good evening, everyone. Am I wrong, Werner, or you did put a question to me, right?
It was a question, and yes. It was the question that Christoph Schönberger had answered in making differences between causal and meaningful relationships, if I understood right his point. And he had questioned the causality I proposed, and it was also a little bit ironical that I tried to formulate. But however, we could discuss. I think it's a serious question behind.
Yes, thank you. 2 points. The first one is the following: the picture shown is the Chamber of Deputies, the Montecitorio, which was designed around 1880. 10 years after the reunification of the country, when the capital town was moved from Florence to Rome. Yeah. So that parliament was the parliament of a monarchy with a different constitutional order, because by that time the Italian constitution was the one given, octroyé, given by the king in 1848. Mm-hmm. The same structure, without changing a seat, was maintained after the dramatic change of order and the creation of the Republic in 1948. So in a sense, I think perhaps too much to say that the place talks about the institutional orders and arrangements, because the same place has been used for two very different constitutional arrangements, and even more for two very different electoral laws. Mm-hmm. Coming to the ironic points set by Werner, it is true that Italy, I think, is the country with the kind of the most high number of changes in government in the last 60 years. But we have to remember that at least until the end of last century, so between 48 and 98, for 50 years, the country has been ruled by a coalition of 5 parties. Yeah. And so all changes occurred within that coalition. And the 5 parties maintained, with the Christian party having the great majority, then the socialists and 3 minor parties, they maintained that, the constitutional, the main policies for the country made by these guys. So it was not so dramatic as in a majoritarian system, having the change of government every 8 months or every 2 years. So to have a blocked system, as it was defined to be, among these 5 parties, did not mean so much in terms of the variety of governments. It was not only the same people changing seats, but it was the same, I would say, the same country maintaining the same economic and political lines. Then there was an attempt to move with a change in the electoral system to a majoritarian system, a mild majoritarian system that did not change at all the structure of the parliament. And then that was relinquished, and we are back to a not majoritarian, to a proportional system. I don't know whether I answered your yes. point. Let me add that I find it very interesting that work on the places of justice and politics, because we are used to work on courts as the place of delivering justice. And in fact, there is an interesting anecdote on that, because Italy, in 1988, we completely reformed the criminal code, the Code of Criminal Procedure, moving from a pure continental system towards a confrontational system, like American criminal procedure, which meant that every courtroom all over the country had to be changed, because until then the place of the how do you say that in German, the judge promoting the cause against the accusation, the
Staatsanwalt.
Yes, he or she was sitting beside the judge. Mm-hmm. And that, of course, was completely against the Anglo-American idea of the 2 sides being equal. So there was a huge restructuring of these, in some cases, getting back to medieval times, courts for justice, in order to make the place coherent with the letter of the criminal procedural code. Thank you.
I think it's interesting to see, as you say, Italy also has developed its spatial arrangements in parliament under a constitutional monarchy, and then kept them on afterwards after changing completely the system. So that's a parallel with the German evolution, but you started from a different starting point. And I find interesting that Italian constitutional monarchy, even in the 19th century, created this design of responsiveness and communication between cabinet and parliament, whereas the Germans created this design where interaction was made particularly difficult, and they kept it even, although they were not forced to keep it by the fact that they were still using the same chamber. I think it's an important point about parliaments to say that most parliaments were shaped in the 19th century, and in many countries, in France and Italy, they still use the chambers they have started to use in the 19th century. But that's not the case in the German case. So it's even more intriguing that the Germans have still kept this arrangement, although they have changed plenary chambers several times during the 20th century.
May I ask a short question? Is the British setting for the members of parliament unique in the world?
It's not unique in the world because across the Commonwealth, the British system has been exported. So you find on Canada, or so you find many places where they have copied the British system. But as far as I know, there is no country outside of the Commonwealth that has really adopted the British system of its own decision.
I'm talking about the physical location of the seats, of course.
Yes, of course. If you look at Canada, they even have the mace. They have everything. They have the speaker's throne in a similar way. So across the Commonwealth, you often have really copies of the House of Commons. But usually it's inside the Commonwealth tradition. It's not outside the Commonwealth tradition.
But I find it to be really sincere. I find it rather uncomfortable to sit so close next to your neighbor in the British Parliament. Okay. Who else would like to intervene in order to clarify the relationship between space, rituals, materialities in the political context and political systems approach and comparisons? Daniel Witte, go ahead.
No, Mareike was first. She was way earlier.
Really? Okay, go ahead.
Thank you, Mr. Schönberger, for this very visual talk, not so text-driven, but visual. I really appreciate that. I have two questions, since you were just reinforcing the point that the parliamentary systems that you were talking about come from the 19th century, and you stressed a few times that the German way of seating was retained throughout all the changes. So what I'm wondering is whether there was ever any discussion on changing it. You explained to us this change in height in the Bonn parliament. Has this ever been questioned, the way of seating? And if so, how did this discussion go? That would be my first question. And then the second one, since you were, again, stressing the 19th century and the parliamentary histories, have you had a look at any more recent democracies at, I don't know, maybe Asia or South America or wherever? And if so, what does it look like there? Are there any significant differences?
Mm-hmm, mm-hmm. Oh, thank you very much for both very interesting questions. As far as the last question is concerned, the interesting phenomenon about new democracies and their plenary chambers is that you usually really get some kind of copy of an existing system. It's rare, as far as I can see. I've tried to really look at many, even recent systems, more or less democratic. You may be aware of the fact that most parliaments are not very democratic systems, and usually they tend to copy one of the models we have. So it's interesting that the number of, let's say, fundamental models of plenary chambers seems to me quite limited. So for the cabinet places, there is a greater variety than for this fundamental. Let's say, do you use the hemicycle? Do you use the horseshoe, or do you use the opposing benches on the British model? As far as Germany is concerned, yes. For reasons of time, I have not dwelled on this matter, but it's really interesting to see that under the Federal Republic, starting very early in the early 1950s, there was a vigorous, huge debate on the parliamentary chamber of the Bundestag, because there were many critics. There were critics, of course, in the political system. The Social Democrats were not happy. They were the eternal opposition of the Federal Republic, and they had this cabinet sitting on these high benches as in the old Reichstag. They didn't like it. Helmut Schmidt, the young Helmut Schmidt, was one of the most vocal critics. He was instrumental in lowering the benches in 1969, because when the Social Democrats came to power, they had still trauma of the high cabinet places, and they made sure in the Grand Coalition that these government or cabinet benches were lowered. But that's more for the anecdote. There was also really a fundamental discussion about seating arrangements, especially the young political science, people like Wilhelm Hennis and others, Dolf Sternberger, were very active in this debate. It's forgotten today, but it was a really interesting debate. The problem of the debate, if you look at it, is that people were at the time still, they were in love with the British system. And so the whole debate was some kind of, shouldn't we copy the House of Commons? And if you read it, it's quite ironic, because the systems are so different and the spatial arrangements are so different that the idea really to establish in Germany in the 1960s a plenary chamber on the model of the House of Commons seemed so far-fetched to me that you read this debate and you say, oh, you should have given some thought on other systems. And people knew the French system, but people didn't like the French system. I think usually the cabinets were against changes, because of course we have a parliamentary system of government, and the seating arrangements are so useful for the cabinet. They are there, they are sitting, they were sitting elevated, they were not really challenged. So this arrangement is so positive for the cabinet in place that they usually don't want any change. So and the debate really was centered so much on Britain that people did not really think about Italy. They did not think about other models. They really thought, can we establish the model of the House of Commons? And for the anecdote, in 1961, the Bundestag voted with a majority to give the credit for reconstructing the Bundestag according to the British model. But then afterwards, they found out that they would have to reconstruct completely, that they could not accommodate the British model in the hall as it was, and so everything petered out without any result. And then the second let's say phase of this was, of course, the circle. So after Britain, 1960s, came the circle in the 1970s. In the 1970s, the people were obsessed with the circle. They thought that democracy should be shown by a circle of members of parliament. We should get rid of the hemicycle, and this was a very important current, more important than the British current, because in the sense today we have 7 state parliaments, Landtage, where they have finally established the circle as seating arrangement. For example, in the Landtag of North Rhine-Westphalia, you have the circle. And in the Bundestag, reconstructed in the 1980s, you also had the circle. So ironically, I would say, because I'm not really convinced by the circle as a model, ironically, the circle was the most important challenger to the established tradition ever. And that's what you see in the Länder Parliament. And there was no other really convincing discussion on a different model. And that's why when they abandoned the circle, when the Bundestag moved back to Berlin, many people didn't like the circle. The experience in the circle was rather bad. The circle is not, in my perspective, a very good model, because in the circle, it works only if everyone speaks from his seat. But they kept the circle, and they kept the rostrum, and they kept the president, and so they kept everything. They kept the cabinet on the right of the presiding officer, and they put all this into a circle. And it didn't work very well, not surprisingly. And then the Bundestag decided, in a certain sense, to get back to an arrangement similar to the older model, but less confrontational. And then you got this elliptical model established in the Bundestag since 1999.
Thank you very much.
Thank you very much. Now, I think it's Daniel Witte, please.
Thank you. I'll try to be brief. Thank you very much for the fascinating material and the presentation, and I'm very convinced by your whole argument. if I may say so, from a social theory point of view, the approaches that you presented in the first part, these would be my go-to approaches and theorists as well, and this is very convincing. And by the way, I wrote a paper with Martha Buchholz on overcoming the logocentrism in comparative constitutional law from a sociological perspective a while ago. Maybe I'll send it to you, and maybe there's something in it that's of interest to you. This question in academic context usually is, you talked about A, but what about B? And why didn't you talk about C? Usually because C is my own field of research. This is not, but I'll ask a question of this type now for a reason. You talked about spatial arrangements for the most part, and what about the temporal dimension of it? If only because space and time are related in many ways, and because you brought up rituals, which I would treat as arrangements of bodies and objects in space and time, always. And I would be interested to hear a bit more, at least, about the way that spatial orders interfere with the temporal dynamics of what is happening inside parliamentary settings, and how it shapes the temporal dynamics of discussions.
Do you have could you give me an example of what you mean by the temporary dimension and how it may relate to these spatial questions?
For example, if a certain way of architecture or seating order steers how people look at each other, how they communicate or do not communicate, are not able to communicate with each other, and so forth. Many things that you've shown us. This might also relate to the temporal structure of debates. For example, if people are placed in a setting with speech and counter speech in several iterations, what about the limitations, temporal limitations to debates? What about the normative order of who is allowed to talk and for how long and so forth? And is there something in there, how to relate these usually very closely related dimensions? And a second very short question would be, and it's related to the first one, have you looked into research on atmosphere and how spatial and temporal structures may influence the atmospheric setting of, for example, parliamentary debates? Hermann Schmitz is a very prominent name in this context, the famous phenomenologist of the body, Leibphänomenologe, which is quite prominent in the discussion right now. And this, I don't know if you're familiar with this. This could be interesting in a comparative perspective if you're starting from the spatial settings, because it's of course a third maybe dimension of this space materiality configurations that you're looking at. This is would be my
Thank you very much for the question. It's of course, it's always, as you said, if you talk about spatial arrangements, there are other interesting aspects of parliamentary settings and of parliamentary proceedings, and temporality is a key factor in the sense of how is speech regulated, how is the order of the speakers. And if you look at the cabinet, because I was talking about cabinets, of course, the question is, when can cabinets intervene? Do they have to submit to the temporary regime of the assembly or not? It's obvious that there is a relation between these arrangements and these at that moment rather legal rules, because it's rules of the constitution, it's rules in the parliamentarische Geschäftsordnung we are talking about. I give you an example. If we have inherited from the constitutional monarchy not only our spatial arrangement and the cabinet bench Bismarck used already, but we have inherited the constitutional rule that members of the cabinet can speak at any time and for any reason and for any object they want, and as long as they want to do so. This is still valid constitutional law, creating some problems And parliamentary law tends to circumvent this by having arrangements that if cabinet members speak, the time allotted to them will be counted against the party groups with which they are related in the Bundestag. But that's not constitutional law. That's just parliamentary practice. And if cabinet members want to speak all the time, they can do so. And the Constitutional Court, even Federal Constitutional Court, has made a decision in 1959. It's Adenauer time, but it's still the leading case on the matter, where it claimed that the speaking order provided by the Constitution was that there was speaking time for the members of the cabinet, and there was speaking time for all the members of parliament. So on the one hand, the cabinet, on the other hand, the whole of parliament. And the critics of this decision, of course, claim that the Constitutional Court fundamentally overlooked the fact that we have parliamentary government now, and that the position defended by cabinet members in parliament usually coincides with the political position of the party groups supporting the cabinet. So there are elements of this temporality of parliamentary speech related, or at least where there are parallels with the spatial arrangements, which brings me back to the point Werner Gebhardt made. The problem is obviously that we have difficulties establishing causality in the sense of this is the cause and this is the effect. But what we can see is really interesting and intriguing parallels between these different regimes, between the constitutional regimes, the time regimes in parliamentary law, and the spatial arrangements. And if there is a lot of coincidences of that, then we might wonder whether there are not some causal relationships maybe going both ways. Spatial arrangements reinforcing these rules, and these rules on their side reinforcing the ideas carried by the spatial arrangements.
I wouldn't start with causality, but some affinities would be, or like
elective
affinities. Yeah, sure. It would be enough analytically, I guess. But yeah. Thank you very much.
And this could be interesting in the end, also for the question that the philosophy of law still would like to raise. That is, where comes the deontic power from concerning the text, the legal order, the imperatives, whether it is really backed by the organizational structures of force and or fraud or whatever kind of incentives to follow and to obey the rule. So this might link this fundamental reflections to the debate we had in the afternoon about the pandemic validity culture and its function in a crisis situation where everybody was looking for the healing medium to heal society from its disorders. Parliaments have also functioned in this context, and it was the parliament that was the location for declaring the state of exception and reducing it, and at least working and playing with this figure that still triggers us at the moment when we think about our current situation. I still have a question, and even more, that I will raise tomorrow, but if you allow, I will just give a hint at it. How do you integrate the appearance of the Ukrainian president on this huge screen and his talk into your understanding of constitutional matters? Because I think this was rather from somebody who is in war, who is a warrior himself, and speaking to the German parliament in that situation. Is there any kind of constitutional interpretation for that? And where do we find it? I know the Geschäftsordnung rather well, Geschäftsführungsordnung rather well, but I would not find a place for that. You will tell us tomorrow, perhaps?
Maybe we can talk about it tomorrow.
Okay, thank you. So thank you very much. Once again, it was very inspiring, and you draw us in the midst of your questions, and that's what a good and an interesting talk has to make.